every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Dolton Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit. A bullshit.
Okay, next.
A bullshit. A bullshit.
Not today. You said that Tiffany was worried about the trustees. Now her focus on her campaign and using them kids. And them kids said, bullshit. A bullshit. We just gonna roll in the bubbles and go to hell home. Okay. All right, let's get to it. So what we're gonna do is just get to the article first. And I feel like I'm yelling, y'all. Tell me if I'm yelling. First, we're going to get to the article, and then we're going to get to the update. Now, no, we're going to do the update first, which is July 5th, and then we're going to do the little flashback. How about that? Let's get to that article, and then we're going to get to the transcripts. Now, guys, as I told you guys, I am going to let the reader read it. She has a great voice. I picked a great voice. I'm going to get all the details, and I want you guys to listen. If you cannot listen, that's okay. I'm going to splice the video. So this video is going to be sectioned off where it's going to just have the full transcript read. Okay. I'm glad. I want to say I'm grateful for you guys being here. Thank you for the broadcast going smoothly. Y'all don't understand how many hiccups was going on. My mouse kept freezing and things like that. Thank you for having patience for Grace Levi. So now let's get to part 2 of tonight's broadcast. Illinois Appellate Court affirms the $33.5 million verdict from the fatal Dolton police crash. Court freezes funds in another case. Now, wait, before we get to that, because that is the funds that they were talking about that froze the account, we're going to, let's just put this jigger back on the screen, okay? What we just saw. I want to just go back to the clip we were watching real quick. Hold on. Y'all know I got it because we got this man talking shit. Like he is doing his thing and even passively threatening the trustees about them needing protection. I believe this is about 27 minutes. Was it? No, it was this fool right here. Here we go.
Okay, you talk about that. Guess what? The bank account, but the money that goes into the bank. Police, they are doing their job. When I called you, you came.
All right, let's put this back on the screen. We're going to put Belcher versus Lacy. Let's just flash back to that. Well, Lacy want to run his damn mouth as though he is a righteous officer doing right. Let's listen to what this man got to say.
Immediately. So I never said that. But at the same time, when something is happening, y'all have to stop saying it's politics. It's not politics. This is reality. Have you looked at the bank account lately? Do you know how much money is in there? Because I don't understand why a resident is coming telling us that we owe her $500 from 5 months ago. So have you looked in the bank account? So let me say this. Let me say this, and then I'm leave it alone because we can go back and forth. We don't have to. Let me finish. We don't. Okay. Because when you say that, guess what? Because you said we're understaffed. We're understaffed because guess what? We're not at comparable salaries for a police officer coming here. Okay, I'll let you go. We're understaffed because every time you get up here, you, Trustee House, Trustee Brown, Trustee Norwood, get up here and say no to something that he said yes. Okay, you talk about that. Guess what? The bank account, but the money that goes into the bank account or could go to the bank account, you vote down. So don't tell me that the money ain't there. I'm telling you what my guys are doing. They are risking their lives for something that can be settled right here in this room. Okay. That's all I'm saying to you. That's fine. So when you say that and you get on TV and you say what you say, don't do that. And anything I said, I will let you let on finish. Don't do that. Because it not only hampers the investigation, it puts my guys in risk.
And let's stop right there. He said what Ms. Belcher said hampers his investigation and put his guys at risk. we're going to show you, we're going to do a little flashback on what actually put his people at risk and put his ass at risk and everybody else in the community. Okay. Now, if you remember, you know, I'm going to always go back to this. This was a moment that truly pissed me off, had my nerves going and everything. Thought my bro was going to be hurt. So if you don't remember, we're going to put the clip up of the Dolton police. Yes, I have it. Chasing Jedediah. This is how Lacy really do. Okay, let's just do a little flashback in my life. Let me see. Y'all know I'm my own producer. I gotta tell you that. I'm gonna get a team. Flashback. All right, let's get it. Oh shit.
So right now I'm being followed by a cop car, and
Block
then
is
he's
hot.
pulling behind me, and I don't know who he is. Why are you following me? Okay, so this is the cop car, and that's Lacy. This is Lacy. This is some cop from some fucking department following me right now. Who are you? It's a completely tinted car. They following me wherever I'm going. I'm not fucking afraid. Who are you? Who are you? You going on the whole other side. Who the fuck are you? I'm not afraid of none of y'all, so don't play no games with me, bro. Don't follow my car. Don't fucking follow my car.
Look at your tax money, Dolton. Look at those wheels. Looking nice.
Have a good day. Have a fucking good day. They literally are following my fucking car, circling me. I don't know who this is, but all of a sudden now that I have a conversation with this man, now this fucking car, and it looked like that shit. Is that a dog? So what's up, bro? Like what's up? Like, what do you want? Move. All right, so now this thing went to a whole nother level.
If y'all know who we talking about, we're gonna put the guy on the screen.
I'm trying to figure out who the fuck this is. That's a blacked out car. It's police plated.
There you go.
It's police plated. You know what, bro? You got me fucked up. Y'all got me good.
This is where your tax money going, Dolton. Remember.
It's police cars all fucking around me, and they don't. These are all Dolton police officers, and I want to tell y'all really got the right nigga. Got the right one, bro. Got the right one. Look, that go another cop car right there. There's a cop car behind me.
Take all your money.
Go talk. These are all cop cars. You feel me? They surrounding my shit. I'm definitely on whatever they're on. What's up, bro? What's good?
Let me see. Can I speed it up a little bit?
I'm not safe right now. I'm not safe, and I'm literally being surrounded by fucking black out police cars. And I love this shit. What's up? I'm gonna just stop. I'm gonna stop. Bet.
This is what people get when we come to Dolton. That's what visitors get when they come to Dolton.
I'm actually beyond P4 right now. So my team, I need y'all to get my shit on my line, please. To be in Dolton. If these are Dolton police cars, you should be in fucking Dolton. Shouldn't you be in Dolton? Shouldn't you be in Dolton? Huh?
Intimidation. Stalking.
I'm not gonna, man, bro.
Unlawfully putting their lights on in another town.
Get your bitch ass out. You gonna chase me, clown.
False
You
report.
gonna fucking follow me. Get your bitch ass out.
If you remember, I just wanted to just show people what thick legs, chicken legs Lacy is actually working with. This is just a little bit. Now let's get to the article. Shout out to Jedediah. God be the glory that you made it out there safe and sound, because that neglect is reckless. Okay, guys. Now I do want to say this because I said that word niggas, and I don't want you guys to take offense to that. As a Hebrew woman and as a daughter of Israel, I understand what the word nigga mean and where it came from. Okay, so there's a land called Negro land that was actually at the inner part of Africa before it was renamed. I need you guys to go research that. That's why they call you nigga, and that's why they changed your name to Black, because you would have figured it out. So I just to say that because it was bothering me, because I know some people just don't understand. They're like, why is she using that word? So sometimes I make it a little bit more funny. I say niggas because that's what they are and that's what we are. But I don't say that out of disrespect. So that was an educational moment. I like to clarify when the spirit say clarify, because I don't want to offend anybody. Okay. Now let's get to it. Now, what I think Kathy was saying, and a few other people in the audience was saying, that the bank account was frozen related to another case. So we're going to look into that case on a later date. Okay. You know, I would do my research, so I don't want to talk too fast about that case, but we're going to read this update that was updated July 5th. This is Yahoo News. You know, I would just get it from the basic place. Decision in 2 lawsuits against the village of Dolton are contributing to the financial troubles, with the village owing $33.5 million from one case and having $440,000 in funds frozen from another case. An Illinois appellate court affirmed June 20th that the $33.5 million verdict on behalf of John Kels, who was unalive following a 2016 police chase in Dolton, and a second man, Dunlap, who was left severely injured, according to the court document. Attorney said that the chase stemmed from a traffic violation after the man's car skipped through a stop sign. Police chased the vehicle for about a mile until the vehicle crashed into a building. Kelsey unalive, while Dunlap was left with severe catastrophic permanent injuries. According to the wrongful death lawsuit filed in November 2019, the ruling from the appellate court in the first judicial district said attorneys claimed the police vehicle had a dashboard camera with footage that, despite a court order, the village never produced. This is you just to get sidetracked. The court can't even get information or documents from the village. No disrespect. How the hell is Lightfoot gonna get it? Y'all know I'm gonna say it again. Lightfoot gonna prove me wrong. I want her to, but baby, somebody gonna have to do a sneak attack to get those documents, because Dolton, she ain't giving up on Dolton documents. Okay, not even for the courts. So when the injury awarded was announced in August 2022, attorney from Love said they believe it had been one of the largest police misconduct case in Illinois history. Shout out to Lacy, trying to disrespect Miss Belcher, talking about you don't know what we do, and when you need help, who gonna come for you? We don't want your ass. How about that? Neighborhood watch. In the case, the village should have settled, said attorney representing the administrator of Kelsey and the guardian of Dunlap. They could have settled for a fraction of this, but somebody wanted to be hard-headed. I don't know if it's Tiffany Henyard. Despite Dolton's appeal, the village never sought to stay on the payment, and it was considered present and due when attorney filed a petition on behalf of the guardian of administrator of the 2 men in the police chase in January, according to the petition. The petition expressed concerns about the village's ability to pay the judgment due to the. That is sad. Okay. Let me start reacting. The petition expressed concerns about the village's ability to pay the judgment due to a breakdown of governments and insufficient insurance coverage. They detail allegations of Mayor Tiffany Henyard spinning woes, such as repeated misappropriation of funds and refusing to disclose details of village spending. Plaintiffs have reason to fear that Dolton is not ordered to take affirmative steps to marshal assets to satisfy the judgment. Yeah. Dolton about to pull Tasha K. I ain't got it. That's what they're going to pull. They're going to be like, baby, I ain't got it. Okay. It says the asset to satisfy the judgment will continue to fail to pay, and the Dolton will, despite and divert asset and divert assets that might have been otherwise been available to satisfy the judgment. And they're talking about Tiffany Henyard spending without grants and mandamus and other relief requests in this complaint. Plaintiff have a dim chance of being paid. The judgment, because there has been a complete breakdown of the Village of Dolton accounting intern control and checks and balancing, endangering plaintiff judgments, it said. LeVay said the village has yet to post bond for the $33.5 million. So there's a bond that needs to be paid before that they're going to just levy the bank account for this $33.5 million, which had occurred 6% per year interest or $2.1 million per year. The petition, village officials declined to comment. So if this was granted 2 years ago, that means that is an extra $4.2 million in debt that's on this $33.5 million owed. The Cook County Court also recently froze about $440,000 in the village funding after a June 24th hearing because Dolton failed to pay settlements in a whistleblower lawsuit from a former Dolton detective, David Graham. So we're going to be looking into that, okay? Graham attorney Patrick Welsh of Griffin Williams, Macomb and Welsh said that Dolton Village Board agreed to pay over $220,000 in attorney fees and costs in sign of checks, but it's just sitting on the mayor's desk. We're still talking about sitting on the desk since March. $4 million sitting on the desk. Trustee Kiana Belcher said that she believed Henyard may have chosen not to send the checks due to the personal agenda and political attacks against Welch, who says she represented people and groups in the village who opposed Henyard administration. The lawsuit was settled February 28th and should have been paid within the following 30 days, Welch said. Since then, the payment has occurred about $4,000 in interest. It's money that citizens shouldn't have to pay to us, Welsh said Friday. Ahead of the hearing scheduled for July 23rd, coming up, Welsh said he plans to file a motion to direct the village bank to turn over the funds. The village failing to pay a settlement to the point that the court freezes fund is totally unprecedented, he said. I've been suing municipalities for over 20 years and never had to do it before, he said, and I'd never heard of it being done. Belcher said it is the disgrace that the mayor's office has not paid the settlement and services as one of many examples of poor financial discretion from Henyard. It's very disturbing when we have to have that type of money on hold when the board approves it a couple of months ago, as we showed you with the proof. And the checks should have been paid out, Belcher said. But that goes back to everyone seeing that the mismanagement of funds with the administration is happening daily. The village will be able to use the remainder of the $440,000 in funds once it pays the settlement, Welsh said. According to the court documents, Dolton has $809,000 in total in the account where the funds were frozen. And that person, I believe she's connected to the freezing of these funds. Was on Jedediah's page the other day. And you remember I was in the audience like, where's the papers? Where's the papers? With my pessimist dad, it's like, where's the papers? There they go. So I'm glad I was able to find it. We continue to validate the things that's going on around here. Again, two families awarded $33.5 million in lawsuit. We're going to play this little short video, and then what we're going to do is get the transcripts read. This is what I want to say to you guys, because most likely you're not going to see my face for the rest of this broadcast. So I'm going to be signing off because this is going to be the part 2 that's going to be edited. I want to say I love you guys and I appreciate you. I want to say thank you for being here with Grace Levi and seeing me for who I really am. My heart is with Dolton, Thornton, and anyone else who have concerns on and off this YouTube street. As you see, I am very diverse. You're going to learn something new from me every day. You're going to be like, damn, she into that, she into this. Yup. because I got too much time on my hand. How about that? So right now, what we're going to do is get to this video, and then right after this, we're going to get the transcript read to you in a nice voice. Okay. I've been on for an hour and 30 minutes. My ears are still plugged, and I think that I did a great job on this broadcast. Let's keep it moving.
A Cook County jury has issued one of the largest police misconduct verdicts in Illinois. A Cook County jury has issued one of the largest police misconduct verdicts in Illinois history.
$33.5 million were awarded to two families in connection to a fatal police chase in Dolton back in 2016. Casey Cronus is live with more on this story. Casey?
Anthony and Sally, one man was killed and another was severely injured when Dolton police were pursuing the car they were passengers in back in 2016 during an attempted traffic stop. This all happened in October of 2016. 19-year-old John Kyles was ejected from the car and died when the driver lost control and collided with a dumpster and parked car. Another passenger, Dwayne Dunlap, suffered a traumatic brain injury and other life-altering injuries. On behalf of the families, attorneys with Lovey and Lovey sued the Village of Dolton and the Dolton police officers involved in that chase for wrongful death and negligence, among other misconduct claims. And last night, a jury awarded $33.5 million to those families, about $10 million for the family of Kyles and about $23 million for Dunlap, to assist with his ongoing medical care.
I miss John so much. No amount of money could bring him back. I appreciate the jury.
Didn't bring back John Kyles, didn't make Dwayne Dunlap whole again, but signaled loud and clear with the magnitude of this verdict that what happened was wrong and unjustified.
We reached out to the Village of Dolton and the Dolton Police Department for their response to this verdict, but have yet to hear back. Live in Fulton Market, Casey Cronus, Fox 32, Chicago.
Dolton police officer Ryan Perez and unknown Dolton police officers chased the car driven by Demetrius Sorrells. Complaint plaintiff ISC, a special administrator of deceased person, John Christopher Kyles, and Dwayne Dunlap, by counsel, Loewy and Loewy, Gardner, Cook, Weisberg, and Renat, and Daniel J. Storr. Complaint as follows. Introduction 1. On or about Sunday, October 9, 2016, at approximately 1 a.m., John Christopher Kyles and Dwayne Dunlap were passengers in a car driven by Demetrius Sorrells. 2. Beginning in the vicinity of the intersection of Greenwood Road and Sibley Boulevard, in Dolton, Illinois, proceeding for approximately 1 mile until a fatal crash at the backside of New Zion Covenant Church, approximately 14239 Greenwood Road. Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and unknown Dolton police officers chased the car driven by Demetrius Sorrells at a very high rate of speed. 3. John Kyles died on the scene as a result of catastrophic injuries suffered as a result of the police chase and crash. 4. John Kyles left surviving his mother, Jelinda Kyles, his father, John Wayne Kyles, his sisters, Aya Seats, Melinda Kyles, Niecy Kyles, and brothers Cedric Chisholm, Antone Brown, and Jordan Kyles, each of whom suffered pecuniary injuries resulting from such death. Filed November 5, 2019, 4:11 p.m. Dorothy Brown Circuit Clerk, Cook County, IL. 2019 L012256. 724-7694. Including grief, sorrow, and mental suffering. 5 Seats was appointed Special Administrator of John Kyles prior to the filing of this complaint. 6 Dwayne Dunlap also suffered severe, catastrophic, and permanent injuries, experienced pain and suffering, and requires future medical treatment and care as a result of the police chase and crash. Count I. Wrongful death of John Christopher Kyles, Village of Dolton, Dolton's Police Sergeant Louis Lacy's, Dolton Police Officer Ryan Perez's, and unknown police officer's negligence. Plaintiff Seats on behalf of decedent John Kyles incorporates herein 1 to 6 from the introduction herein. 7 On said date and all time pertinent hereto, defendant Village of Dolton, acting through its agents and employees, had a duty to refrain from negligent operation of its official vehicles in the exercise of their official duties as police officers. 8 That notwithstanding the aforesaid duty, the Village of Dolton, Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and unknown police officers failed to exercise due care in operation of their police vehicles and were negligent in one or more of the following respects. A. The necessity of immediate apprehension did not outweigh the level of inherent danger created by the pursuit. B. Improperly engaged in pursuit when the volume of traffic made it unsafe. C. Chased the car in which John Christopher Kyles and Dwayne Dunlap were passengers at speeds and / or engaged in maneuvers which created an unwarranted danger. D. Failed to abandon the vehicle pursuit considering the speeds involved, volume of traffic, weather conditions, road conditions, and considering the distances that indicated that further pursuit would endanger others. E. Participated in caravanning and pursuit paralleling. F. Failed to abandon the chase when it was the most reasonable course of action. G. Disobeyed direct command to abandon the chase. H. Used an unmarked Dolton Police Department vehicle to participate in the chase. I. Engaged in the pursuit with one primary and one backup squad car. J. Failed to immediately notify the dispatcher and supervisors that a pursuit was in progress. K. Failed to immediately notify dispatch of the specific reason for the pursuit, including known laws violated. L. Engaged in a motor vehicle pursuit when the most serious offense which the pursuit vehicle was wanted for was a hazardous traffic offense. M. Continued the pursuit for a hazardous traffic offense after the pursuit vehicle disregarded stop signs and violated rules and regulations applicable to the Dolton Police Department as to police vehicle pursuits. 9. As a direct and proximate result of one or more of the aforesaid negligent acts and/or omissions by defendants, John Christopher Kyles was catastrophically injured and died from those injuries. Wherefore, plaintiff prays for judgment against defendant Village of Dolton, Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and unknown defendant Dolton Police Officers, in excess of the jurisdictional limits of the Law Division of the Circuit Court of Cook County. For costs with interest in bringing this action, and for such other relief for plaintiff as the court deems fair and just. Count 2. Wrongful death of John Christopher Kyles, Village of Dolton's, Police Sergeant Louis Lacy's, Dolton Police Officer Ryan Perez's, and unknown Dolton Police Officers' willful and wanton conduct. Plaintiff Seats incorporates herein 1 to 6 from the introduction herein. 7 On said date and all time pertinent hereto, defendant Village of Dolton, acting through its agents and employees, Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and including other as of yet unknown police officers, had a duty to refrain from willful and wanton conduct in the operation of its official vehicles in the exercise of their official duties as police officers. 8 That notwithstanding the aforesaid duty, the Village of Dolton, Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and unknown police officers failed to exercise due care in operation of their police vehicles and were willful and wanton in one or more of the following respects. A. The necessity of immediate apprehension did not outweigh the level of inherent danger created by the pursuit. being improperly engaged in pursuit when the volume of traffic made it unsafe. C. Chased the car in which John Christopher Kiles and Dwayne Dunlap were passengers at speeds and / or engaged in maneuvers which created an unwarranted danger. D. Failed to abandon the vehicle pursuit considering the speeds involved, volume of traffic, weather conditions, road conditions, and considering the distances that indicated that further pursuit would endanger others. E. Participated in caravanning and pursuit paralleling. F. Failed to abandon the chase when it was the most reasonable course of action. G. Disobeyed direct command to abandon the chase. H. Used an unmarked Dolton Police Department vehicle to participate in the chase. I. Engaged in the pursuit with one primary and one backup squad car. J. Failed to immediately notify the dispatcher and supervisors that a pursuit was in progress. K. Failed to immediately notify dispatch of the specific reason for the pursuit, including known laws violated. L. Engaged in a motor vehicle pursuit when the most serious offense which the pursuit vehicle was wanted for was a hazardous traffic offense. M. Continued the pursuit for a hazardous traffic offense after the pursuit vehicle disregarded stop signs. N. Violated rules and regulations applicable to the Dolton Police Department as to police vehicle pursuits. 9. As a direct and proximate result of one or more of the aforesaid willful and wanton acts and/or omissions by defendants, John Christopher Kiles was catastrophically injured and died from those injuries. Wherefore, costs with interest in bringing this action, exemplary damages against the unknown police officers in their individual capacities, to the extent provided for by law, and for such other relief for plaintiff as the court deems fair and just. Count 3. Village of Dolton's, Police Sergeant Louis Lacy's, Dolton Police Officer Ryan Perez's, and unknown police officer's negligence as to Dwayne Dunlap. Plaintiff, Village of Dolton's, Police Sergeant Louis Lacy's, Dolton Police Officer Ryan Perez's, and unknown Dolton police officers' willful and wanton conduct as to Dwayne Dunlap. Count I above as count 3 herein. 9. As a direct and proximate result of one or more of the aforesaid willful and wanton acts and/or omissions by defendants, plaintiff Dwayne Dunlap was catastrophically injured. 9. As a direct and proximate result of one or more of the aforesaid willful and wanton acts and/or omissions by defendants, John Christopher Kiles was catastrophically injured and died from those injuries. 10. SGT Lacy had a bad driving record, having been involved in at least 6 previous on-duty automobile collisions while driving, resulting in personal injury. 11. One of the earlier on-duty crashes involving personal injury occurred at the same location, 14212 Chicago Road, Dolton, American Samoa, where the chase involving decedent terminated. 12. In those earlier crash resulting in personal injury, defendant Lacy had driven without due regard for the safety of others and of himself, was at fault and had driven negligently or recklessly to the point of willful and wanton conduct. 13. In those earlier occasions, defendant Lacy had activated his emergency equipment while driving in excess of the speed limit and endangered the life and property of others, and actually caused personal injury. In violation of the Illinois Motor Vehicle Code, which prohibits officers speeding with their emergency equipment activated where such conduct endangers life or property. 14. Notwithstanding the Village of Dolton's actual knowledge that defendant Lacy's repeated instances of unsafe driving, defendant Dolton failed to supervise and discipline him. 15. And, on those occasions where discipline was recommended, the village failed to follow through and actually discipline defendant Lacy. 16. As a result of the Village of Dolton's practice and culture of failing to prevent, investigate, and discipline SGT Lacy's dangerous driving, SGT Lacy felt free to drive negligently and recklessly with his emergency equipment activated, knowing that he would not be disciplined. 17. In addition to his bad driving record, SGT Lacy had an excessively high number of other cases as a civil defendant, 7. Plus workman's compensation litigation arising out of injuring himself while driving with emergency equipment turned on in a dangerous manner that endangered life and property and actually resulted in injury to himself and others, in addition to totaling and damaging Dolton police vehicles. The high number of cases for one officer was a red flag that should have triggered scrutiny, yet Dolton failed to investigate and supervise defendant Lacy. 18. In addition, SGT. Lacy was well known to the village of Dolton to be a supervisor who fell below the minimum standards for being a supervisor. Consequently, SGT. Lacy was demoted, for which he is suing Dolton, and the Murphy firm which herein purports to represent SGT Lacy, is simultaneously representing Dolton adverse to SGT Lacy, in which litigation Dolton has taken the opposite position as herein, asserting the SGT Lacy was incompetent. Yet even though Lacy was demoted to sergeant, and assigned to the overnight shift, the village of Dolton failed to give Sergeant Lacy any further training, education, or supervision to remedy his supervisory deficiencies. 19. As a result, Sergeant Lacy and the village of Dolton was negligent in supervising defendant Ryan Perez, a young probationary officer who had been a full-time police officer for less than a year on the date of the unlawful and tragic chase that resulted in the death of John Kiles and profound and permanent brain injury to plaintiff Dwayne Dunlap 20. In addition, the defendant village of Dolton wholly lacks any system of tracking officer as to their performance, and even fails to keep its personnel files in an organized manner, allowing for a systematic ongoing method of keeping track of and ascertain whether officers in their day-to-day activities are complying with minimal standards as to the duty of care owed to the public. 21. In addition, Dolton has wholly failed to supervise police chases in the years prior to the instant chase. As a result, Dolton has one of the highest, if not highest, rates of police chases in Illinois. In the 5 years prior to the instant police chase, Dolton had been involved in approximately 50 police chases in which approximately half resulted in crashes involving personal injury, or death, or property damage. 22. Such a high rate of crashes, and high rate of injury or property damage, put Dolton on notice that its officers were engaging in unsafe chases, yet Dolton negligently and recklessly failed to supervise its police officers in insisting that they follow the standard of care as police officers, thereby giving defendants Lacy and Perez the green light to engage in an illegal chase, because they knew that no matter how reckless their conduct was that they would not be disciplined. 23. Defendant Perez was a 22-year-old rookie probationary police officer, having been hired less than a year before the unlawful and fatal chase at issue. In that 11-month period as a probationary officer, he became a defendant in 4 cases, an extraordinary number for any police officer, let alone an at-will probationary officer who was subject to being discharged without cause. In addition, in less than 1 year, defendant Perez was directly responsible for the death of 2 persons 2 separate occasions and is believed to have been responsible for the death of a 3rd person. Had the village of Dolton had a proper tracking system, probationary officer Ryan Perez would have been removed prior to October 9, 2016. 24. The village of Dolton purports to have fully complied with discovery as to defendant Perez's personnel file, which consists of 24 pages. Plaintiffs seriously doubt that, and Rule 201 conversations have been unsuccessful. Prior to becoming a probationary Dolton police officer, defendant had been a part-time Dolton police officer for 14 months while working at Walmart as a shelf stocker. Defendant Perez's personnel file do not show any training prior to hiring as full-time police officer other than being taught how to shoot a gun. And the statutory requirements for hiring as full-time police officer do not provide for any waiver of training as a part-time officer. 25. In addition, the standard of care in hiring police officers includes polygraph testing, psychological testing, and statutorily mandated taking and ranking on a competitive police officer eligibility list. The personnel file that the village of Dolton asserts is complete fails to show that defendant Perez was subject to the standard vetting process prior to being hired. 26. As to defendant Lacy, he was initially hired as an auxiliary police officer. An auxiliary police officer is not a police officer as defined by Illinois law. Defendant Lacy was hired as a police officer. Statutorily, defendant Lacy was not entitled to any waivers or preference by virtue of his earlier employment as an auxiliary police officer. Yet, Lacy was hired through the back door, having never been placed on a merit-based eligibility hiring list as is statutorily required, or having been subject to psychological and polygraph testing, which are universally recognized as a threshold practice in exercising due care in hiring police officers. 27. Thus, it appears that the hiring of defendants Perez and Lacy was extraordinary as to each, and each was hired through the back door instead of being vetted as part of standard law enforcement. Defendants Perez and Lacy should never have been hired, and, if they had not been hired, they would not have been placed in the position to harm plaintiffs. Count B. Village of Dolton's breach of duty to train and supervise. Counts I-4 of this complaint are incorporated herein. 28. In committing the acts alleged in the preceding paragraphs, Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and unknown defendant Dolton Police officers, were members of the Dolton Police Department, and agents of defendant Village of Dolton, acting at all relevant times within the scope of their employment. 29. The Dolton Police Department at all times relevant had a duty to properly train, supervise, and discipline Dolton Police Department officers in relation to police pursuits. 30. The Dolton Police Department breached that duty by failing to properly train, supervise, and discipline the agents involved in the instant complaint of chase in the particulars described above and incorporated herein by reference. 31. As a direct and proximate result of one or more of the aforesaid failures to train and supervise the Dolton police officers involved in the chase, John Christopher Kiles was catastrophically injured and died from those injuries. Count 6. Village of Dolton's breach of duty in hiring, negligence. Counts I-4 of this complaint are incorporated herein. 32. The defendant Village of Dolton and its police department at all times relevant had a duty to exercise due care in hiring police officers. 33. The Village of Dolton and its police department breached those duties by failing to exercise due care in hiring defendants Lacy and Perez in the particulars described above and incorporated herein by reference. 34. As a direct and proximate result of one or more of the aforesaid failures to train and supervise the Dolton police officers involved in the chase, John Christopher Kiles was catastrophically injured and died from those injuries. 35. The Village of Dolton and its police department at all times relevant had a duty to refrain from willful and wanton conduct in hiring police officers. 36. The Village of Dolton and its police department breached that duty by engaging in willful and wanton conduct and by failing to exercise due care in hiring defendants Lacy and Perez in the particulars described above and incorporated herein by reference. 37. As a direct and proximate result of one or more of the aforesaid failure to train and supervise the Dolton police officers involved in the chase, John Christopher Kiles was catastrophically injured and died from those injuries. Count IIX Village of Dolton's respondeat superior liability. Counts I-4 of this complaint are incorporated herein. 10. In committing the acts alleged in the preceding paragraphs, Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and unknown Dolton Police Department police officers, were members of the Dolton Police Department, and agents of defendant Village of Dolton, acting at all relevant times within the scope of their employment. 11. Defendant Village of Dolton is liable as principal for all torts committed by its agents. 11. Dolton Police Sergeant Louis Lacy, Dolton Police Officer Ryan Perez, and unknown defendant Dolton police officers who participated in the chase were employees of the Village of Dolton who acted within the scope of their employment in committing the misconduct. Count X, negligence 1. Plaintiffs incorporates herein 1 to 6 from the introduction herein. 7. Defendant Demetrius Sorrells owed the deceased, John Christopher Kiles, and Dwayne Dunlap, the duty of ordinary care. 8. Defendant Sorrells breached that duty by driving at an excessive rate of speed and ignoring police commands. 9. As a direct and proximate result of one or more of the aforesaid negligent acts and/or omissions by defendant Sorrells. 7. Defendant Perez's squad car was equipped with dashcam video and audio recording ability which provided that upon the squad car's emergency lights being activated the dashcam automatically turned on. 8. Defendant Perez activated his emergency lights. 9. Dolton however had not produced the dashcam video and audio. 10. Either defendant Perez failed to preserve the dashcam video and audio after the conclusion of the chase, or he destroyed the dashcam video and audio after the conclusion of the chase.
Wow.
Or he deliberately and intentionally disabled the automatic turn on the dashcam video and audio record function at some point either before or after the chase. 11 dashcams are installed in police squad cars for the protection of the public. 12 Dolton has internal rules and regulations which require dashcam video and audio creation and retention upon squad car emergency equipment being activated. 13. Illinois state standards require creation and preservation of dashcam video and audio. 14 Dolton has admitted in a memo from a Dolton police supervisor that Dolton failed to preserve dashcam. 15. The state standards and the village's internal standards created a duty upon defendant Perez to create and preserve dashcam evidence. 16. The mechanics of the Dolton dashcam system automatically records audio and video and is retrievable by the patrol officer's commanding officer for 16 hours after the event. Thus, a secondary internal duty was created, but because defendants Perez and Lacy concealed the chase from their commanding officers failed to act to preserve the video and audio within the 16-hour time period. 17. Even if the state and defendant village had not created standards as to officer conduct as to creation and preservation of dashcam video, which it did, a reasonable person in defendant Perez's shoes should have foreseen that the evidence was material to a potential civil action or criminal action. 18. And again, even if the state and defendant village had not created standards as to officer conduct as to creation and preservation of dashcam video, which it did, the village assumed the duty by creating and preserving video in this particular case as shown by the preservation of dashcam video of Officer Bruno, the 4th squad car to arrive at the chase termination point. 19. A duty was further created by plaintiff's October 17, 2016 letter hand-delivered to Dolton Police Chief Collins directing his attention to the probate nature of the dashcam and GPS and directing Dolton to retain such evidence. 20. The preservation order in this case, entered October 21, 2016, further required Dolton to preserve evidence, including dashcam video and GPS records. 21. Outstanding discovery requests both in the criminal case and the instant case further created an affirmative duty upon the village of Dolton to preserve evidence. 22. In light of the circumstances, it was the duty of defendant village of Dolton, individually, and through its agents, including counsel, to exercise ordinary care and caution to preserve the integrity of evidence material to this potential and actual civil action arising from the chase and crash. 23. In addition to failing to preserve dashcam video and audio, defendant Perez, either intentionally or unintentionally, pressed a button on his GPS unit during the chase that disabled the ability of his GPS unit to record his maximum mph speed, resulting in a blank maximum speed entry during the chase. 24. Said action violated Dolton's internal standards, and, in addition, defendant Perez had assumed the duty of preserving evidence of his maximum speed in that he recorded his maximum speed prior to and after he turned off that function. 25. Defendant Dolton further engaged in spoliation by failing to preserve the audio of Officer Bruno's dashcam and failed to preserve dashcam video and audio as to Officers McNeil, Johnson, and Sheehan. 26. Dolton participated in further actions and inactions spoliating evidence, but those other actions are as yet unknown, in that defendant Dolton has not yet complied with discovery as to spoliation. 27. The city is responsible under respondeat superior for the actions of its agents. 28. As a result of one or more of the negligent acts or omissions, or intentional acts or omissions, of defendant village of Dolton, through its employees and agents, known and unknown, plaintiffs have been injured in their ability to prosecute and enforce their legal rights against the village of Dolton defendants and have been irrevocably prejudiced by the destruction and/or modification of the aforestated material evidence as above described. 29. As a direct and proximate result of said destruction and/or modification, plaintiffs are severely prejudiced in their ability to prove the underlying suit against the Village of Dolton defendants. Wherefore, plaintiffs prays for judgment against defendant Village of Dolton in excess of the jurisdictional limits of the Law Division of the Circuit Court of Cook County, for costs with interest in bringing this action, and for such other relief for plaintiffs as the court deems fair and just.
All right. So you heard it here in detail. Exactly what happened during the police pursuit. What we're going to do here is we're going to stop right here today. I'm going to bring myself back on the screen. Let me see. Yes, I was here with you guys. Thank you for participating. You see, I was putting your comments in the bottom. We learned a lot. Okay. We're going to continue this with the part 2 tomorrow, where we're going to read the full appeals process, the full appeal paper. But I'm just going to read you the top. And it says, as ordered, we affirm the jury verdict in the plaintiff's favor on the claim of the spoliation of evidence or defendant contents. So based on that, they are going with and affirming the judgment because they did not preserve evidence. The trial court should have plaintiff willful and wanton spoliation claim. Plaintiffs failed to provide their spoliation claim. This is of the Village of Dolton. Given Illinois pattern jury's instructions, 501 was error. So administrative action, what they were filing was incorrect and they didn't follow the guidelines. Plaintiff counsel made improper comments during closing statements. All of that matters in the middle of trial. That's why you see me so passionate on what's happening with the YSL trial. Everything is part of the administrative action. And lastly, the trial court should have given defendant proposed special interrogation. So that is the beginning of the appeal court process. The appeal court paper that was on June 20th, 2024, just a few days ago. So we're going to follow up tomorrow. We're going to do the broadcast after we do our tax broadcast. Okay. So this is going to be done probably around 2 p.m. in the afternoon. If you don't catch it, please hit the playback. What you're going to see tomorrow available in the morning is actually this particular section that highlights this read. For the Village of Dolton residents who don't know specifically what happened, please like and share this video. Support this page. I appreciate you guys. We went 2 hours today. I'm not trying to go 3 hours. My ears are still plugged, but I'm here for it, baby. And with that goes to say, I will see you tomorrow morning where we're going to be going into understanding taxes in Dolton and ways to appeal your taxes. But until then, I want you guys to remember our goal is to vote her ass out and have her unasked this seat so she can stop talking shit like this.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections. You were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit. A bullshit.
Yeah, hatred and envy, don't let it tempt me. I move defensive. Evil offends me, I yell repentance. We come from trenches. I'm in the secret place of the Most High, you can't offend me. Hamashiach built many mansions, that's where my rent be. Father, help me overcome. People who I used to look up to, they turning foes for none. Father, you my strength and you my courage. I feel both for some. I wanna feel your spirit on my body like it's clothes or something. Put my vision in your one direction like it's froze or something.
Drunk as, yeah. Yes, today the city. Imagine if my small business blew up overnight and I woke up to some sales. Boost this video so people who like my products can find me.
Algorithm. Where you at, bitch? Because I'm tired of posting viral content and getting 2.5 likes. We finna fight, ho.